Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, everybody. My name is Rasa Fumagalli. I'm an attorney and the Director of Medicare Secondary Payer Compliance here at Synergy Settlement Services. I'd like to welcome you to this month's Third Thursday webinar. Today's webinar is entitled Complete Medicare Secondary Payer Compliance, All You Need to Know. During today's webinar, I'm going to be covering Medicare Secondary Payer Compliance Obligations by looking at the Medicare Secondary Payer Act itself. We're going to address conditional payments or payments that were made by Medicare that are injury related prior to settlement. We're going to look at what Medicare's potential interest may be in post-settlement injury-related treatment, as well as the piece that puts it all together, Section 111 Mandatory Insurer Reporting. We're also going to take a look at some of the inappropriate Medicare Secondary Payer Compliance settlement terms that you might be faced with when you have reached a settlement agreement. I'm also going to go over Synergy's Medicare Secondary Payer 360 complete suite of services. After the webinar, we're going to have probably 10 minutes for live questions and answers. So I hope that you will use the chat box to post any questions that you are faced with when it comes to Medicare Secondary Payer Compliance challenges in your cases. So let's take a look at what the Medicare Secondary Payer obligations are in a case. So Medicare is a payer of last resort or a secondary payer when payment has been made or can reasonably be expected to be made under a workers' comp law or plan of the U.S. or a state or under an automobile or liability insurance policy or plan. And this includes a self-insured plan or under no-fault insurance. So any Medicare secondary payer compliance obligation is going to circle back to this provision. And because Medicare is a secondary payer, Section 411.2 of 42 CFR states that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under workers' comp, liability, or no-fault insurance plan. Now, even though Medicare is a payer of last resort or a secondary payer, they don't want the Medicare beneficiary to go without treatment after they have an injury. So there is an exception to Medicare being prohibited from making payment. Medicare is able to make a payment when payment is not reasonably expected to be made promptly, and that's defined as 120 days of receipt of the claim by the primary payer. So if Medicare makes a payment before a case settles and the payment involves injury-related treatment, Medicare is entitled to be reimbursed for that conditional payment. This reimbursement obligation kicks in when there's a judgment against the defendant. There is a payment conditioned upon the recipient's compromise, waiver, or release of payment for items included in a claim against the primary payer or by other means. it's important to note that in this particular provision, it also states that that reimbursement obligation is demonstrated whether or not there is a determination or admission of liability. Another thing to be aware of is that this reimbursement obligation is also demonstrated whenever there are conditions that are released in the settlement. So it is way better to actually have a very focused approach to what conditions are actually being settled in the case as opposed to throwing everything in, because these various diagnosis codes are going to be reported to Medicare, and Medicare may view all these other conditions as conditions for which they are a secondary payer. So there are essentially three different components to Medicare Secondary Payer Compliance and what your obligations are. So the first obligation involves the need to address Medicare's payments for pre-settlement injury-related treatment, which are conditional payments. Medicare is going to know that there has been an accident in a settlement because of the mandatory insurer reporting obligation under Section 111. Since Medicare is prohibited from making payment when payment has been made, which is what the settlement is actually considered in the eyes of Medicare, you have to consider whether there's going to be any post-settlement injury-related treatment, and that is a consideration of Medicare's interest in the future medical in the claim. In light of the Section 111 mandatory insurer reporting obligation, Medicare is going to have notice of a settlement, which means that Medicare is going to be looking for reimbursement of conditional payments that were made. One of the things that you have to consider when we're talking about Medicare secondary payer obligations is to be mindful of the fact that conditional payment information oftentimes is interim conditional payment information that may be updated and have a different figure after the case fully settles. There are also different types of Medicare coverage. So when you have a client who is a current Medicare beneficiary, you should identify the type of Medicare coverage they're enrolled in. So Medicare Part A is hospital coverage, and it covers inpatient hospital stays, care in a skilled nursing facility, hospice care, and some home health care. Traditional Medicare Part B insurance will cover certain doctor services, outpatient care, preventive services, and medical supplies or durable medical equipment. So if your client is enrolled in traditional Medicare Part A and Part B, you are going to be able to request the conditional payment information from Medicare because they will have this information in their database, which they can share with you. Your client may also be enrolled in a Medicare Advantage plan at some point during the life of their claim if they choose to switch from traditional Medicare Part A and Part B. So Medicare Advantage plan is administered by a private insurance company, but it's paid a fixed amount each month by Medicare. So for example, Humana has a Medicare Advantage plan. United Health has Medicare Advantage plans as well as Blue Cross Blue Shield and so forth. So the Medicare Part C and Part D plans, they include all of the Part A and Part B coverage plus more. So the Part D plans are drug plans that are Medicare covered. You should also be aware that the Medicare Advantage plans use the Medicare Secondary Payer Act as their recovery vehicle. If you are looking to find out what a Medicare Advantage plan paid, you would have to go seek this information from the plan itself. Medicare does not share the Part D information and the Part C information through the Benefits Coordination and Recovery Center or the entity that you would reach out to when there's a traditional Medicare Part A or Part B plan. The reason everybody is concerned about reimbursing Medicare is that there are some significant penalties that can come into play when Medicare is not paid. 42 CFR 411.24 talks about the fact that CMS has a right of action to recover its payments from a primary payer a beneficiary, provider, supplier, physician, attorney, state agency, and a private insurer that has received a primary payment. The reason that a lot of defendants and insurance carriers do put in this overly broad, inappropriate Medicare Secondary Payer Compliance templates is because they are concerned about this ability of Medicare to actually seek recovery for conditional payments from the primary payer. When a primary plan fails to address conditional payments, or the plaintiff fails to address conditional payments, the Medicare Secondary Payer Act provides for a private cause of action for double damages. And this is found in Section 1395 YB3A, which basically states that there is a private cause of action for damages, which shall be in an amount double the amount otherwise provided when a primary plan fails to provide for primary payment or appropriate reimbursement. There's no doubt that Medicare takes their reimbursement seriously. So let's take a look at one of the older cases where a claimant's attorney was pursued. And this is a 2009 claim called United States versus Harris. Now, Harris was representing a plaintiff who was a Medicare beneficiary. He entered into a settlement agreement with the defense for $25,000. Medicare had made conditional payments that were in the area of $22,500. After Medicare was notified of the settlement and you had the reduction for procurement costs, Medicare issued a final demand seeking $10,253. For whatever reason, the attorney did not pay and his client did not pay. So Medicare sues the attorney in federal court as a third party who received payment from a primary payer or the defendant. And the attorney filed a motion to dismiss, stating that the only thing he had to do was let Medicare know that there was a settlement. And, the court disagreed and they held that a primary plan, whether it's the insurance company, the attorney, or the other parties that we previously enumerated, can be held liable. So it's unclear why the attorney thought that all he had to do was advise Medicare about the settlement, especially when they had a conditional payment demand, which always clearly sets out what the obligation is. So the attorney in a case should really pay attention to make sure that the conditional payments that are being claimed in connection with the settlement are resolved. So we've had a continuation, though, of law firms that choose to ignore conditional payment demands. And if you fast forward here, you can see that the Department of Justice is actively engaged in pursuing plaintiff firms for unpaid Medicare debts. Let's take a look at a situation where there was a medical malpractice claim and the law firm's client received a $1 million settlement in 2015. Medicare is given notice of the settlement and they asserted a conditional payment recovery claim. The firm did not reimburse Medicare even when the debt became final by way of a final demand. And nothing happens then for several years until we fast forward to March of 2019. At that point, there was an announcement by the U.S. Attorney for Maryland that Maryland's personal injury law firm had agreed to pay the U.S. $250,000 to settle claims that it did not reimburse Medicare for conditional payments that had been made on behalf of the firm's client. In connection with this settlement agreement, the law firm also had to designate a person at the firm that is solely responsible for paying the Medicare secondary payer debts. That person has to be a trained designated employee, and there was an obligation to review any outstanding debts with a designated employee at least every 6 months to ensure compliance. Here's a quote from the U.S. Attorney in the case. He wrote, "The settlement reminds attorneys of their obligation to reimburse Medicare for conditional payments after receiving settlement or judgment proceeds for their clients. The settlement should also remind attorneys not to disburse settlement proceeds until receipt of a final demand from Medicare to pay the outstanding debt. We intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for its conditional payments." In addition to the Maryland case, you can see that the Department of Justice has also entered into settlement agreements that we know of with at least 3 other firms in November of 2019, January of 2020, and the most recent one is August of 2020. As I mentioned earlier, at this time, about 39% of all Medicare beneficiaries are enrolled in a Medicare Advantage plan. And because of this, it is really important to be mindful that the private cause of action has been extended to Medicare Advantage plans. 42 CFR for Section 422-108F specifically states that Medicare Advantage organizations will exercise the same rights to recover from a primary plan, entity, or individual as the Secretary exercises under the MSP regulations in subparts B through D of Part 411 of this chapter. This right of recovery by the Medicare Advantage organizations is also discussed in a memo from CMS from December of 2011. This memo indicated that Medicare Advantage plans have the same rights to recover as Medicare. We have seen since 2012 litigation in this regard. The very first case that found a Medicare Advantage plan could maintain a private cause of action to recover conditional payments made on behalf of a beneficiary was in re Avandia, and that was a Third Circuit case. There was also a case in 2016 where Humana sued a plaintiff's attorney for failure to reimburse conditional payments. The court in the Fourth Circuit allowed the Medicare Advantage plan's suit to proceed in 2016. There is also the case of Humana Medical Plan versus Western Heritage, which was decided by the 11th Circuit in 2016. This case indicated that Humana was entitled to double their lien amount against Western Heritage. The case also addresses a situation where Western Heritage had actually reimbursed the beneficiary for the payments that Humana was seeking, and it was on the beneficiary's shoulders to actually reimburse Humana. So the Humana Medical Plan versus Western Heritage case indicated that a primary payer has to reimburse Medicare even though they've already reimbursed the Medicare beneficiary or other party. And that specific provision is outlined in 42 CFR section 411.24. So as a practitioner, it's important to understand the difference between a final conditional payment demand, which is a fixed amount, as opposed to an interim conditional payment number, which may change. It's also important that you realize that you cannot get information on Medicare Advantage plan payments in the same way as you can secure traditional Medicare Part A and Part B payments from the Benefits Coordination and Recovery Center. So the Medicare beneficiary's report of a claim to the BCRC will result in the BCRC providing conditional payment information under Medicare Part A or Part B. If you want to obtain information regarding the Medicare Part C and Part D payments, you're going to have to go to the plans themselves. And another thing that you should consider and you should be mindful of is the fact that there are 2 different types of reporting going on when it comes to liability cases and workers' comp cases. So a Medicare beneficiary has an obligation to report an accident to Medicare, and this obligation is part of their process when they enroll in Medicare. And that is a very different type of report than the report that is done by the responsible reporting entity for a primary plan under Section 111. Section 111 reporting is a mandatory insurer reporting obligation that is placed on the defendant and the RRE for the primary plan. When a case involving a current Medicare beneficiary settles and it's a liability case involving a physical trauma and the settlement exceeds $750, the primary plan's RRE is going to make their Section 111 total payment obligation to claimant TPOC report. Another thing you have to be aware of is that when you have a case that has actually been in your office for an extended period of time, it's quite possible that you may have a situation where your client, the Medicare beneficiary, has enrolled in different plans over the life of the claim. He may start out enrolled in a traditional Medicare Part A and Part B plan. 3 years go by, he may switch over to a Medicare Advantage plan. After another year or so, they might switch back to traditional Medicare, or they may enroll in a completely different Advantage plan. So it's important to stay on top of the different types of coverage that the Medicare beneficiary may have over the life of the claim. There's some things you can do to help make the conditional payment process go more smoothly in a claim. I would recommend that you request copies of your client Medicare beneficiaries' health insurance cards once you sign them up. It's also a good idea to request updated information during the life of the claim. The medical records should be reviewed to see who is being billed at various times over the years of treatment. You should also be able to see the billing statements in the pharmacy records. It's a good idea to begin this investigation early. If your client does not remember the various plans that they've been enrolled in when it comes to Medicare, I would suggest that they open up and they register an online account on mymedicare.gov. It's a pretty good website that will show the different plans that your client was enrolled in once they became eligible for Medicare. The next few slides are going to address the Medicare Lien process. The information has been taken from the Medicare website, which is pretty decent when it comes to Medicare Secondary Payer information. So the way that you initiate the Medicare Lien process is to have the Medicare beneficiary report the case to the BCRC. And this reporting obligation kicks in whenever there's a pending liability, no fault, or workers' comp claim. The report of the claim is the very first step in the whole Medicare Secondary Payer recovery process. The information that you're going to have to report is going to include your client's or the Medicare beneficiary's full name, Medicare number, gender, date of birth, complete address, and phone number. You are also going to have to share information regarding the type of claim, the insurer or workers' compensation carrier's name and address, the description of the alleged injury, illness, or harm. And I would recommend that there actually be a discussion and some coordination to make sure that the injury which is being reported is really one that can be tied into the accident. And of course, you are also going to have to report the date of the injury or the accident. The Medicare Secondary Payer portal is a very helpful tool when it comes to conditional payment recovery. Synergy uses it often. You can actually provide this first report via the Medicare Secondary Payer Recovery Portal, and here is a screenshot of what it would look like. Once the initial Medicare Secondary Payer occurrence event is posted, the BCRC is going to send the beneficiary the rights and responsibilities letter. It essentially explains how the recovery process works and what information is going to be needed from you and what information you can expect from the BCRC. This is a screenshot of what the letter looks like. The next thing that happens is that Medicare is going to start looking at payments that were made in connection with the diagnosis code or injury that was reported to them. So they are going to start their search from the date of incident, and they are going to provide a temporary figure which is subject to change, and this would be called the conditional payment letter. Here is a screenshot of what the conditional payment letter will look like. As you can see, the letter states that, for example, as of the date of this letter and based upon available information, Medicare has identified $2,795 in conditional payments that we believe are associated with your case. Further down in the report, it talks about that they are still investigating the case to obtain any other outstanding Medicare conditional payment information, and it specifically indicates that this information is not final. So when you receive a letter like this, you should not rely on this figure as being the final figure. It clearly states that this is an interim figure. This is an example of a payment summary form. As you can see, there are different line items and they reflect ICD diagnosis codes. It's important to review the diagnosis codes to make sure that they're consistent with the type of injury that was sustained in the accident. If there are numerous diagnosis codes listed on one line, typically the code that is bolded is the main diagnosis code, and the remaining codes are simply part of an electronic record. This is, however, an area that can be reviewed and disputed during a conditional payment dispute based on whatever the medical records may show. As I mentioned earlier, the Medicare Secondary Payer Recovery Portal is a nice tool that allows the conditional payment recovery process to flow a bit more smoothly. These are some of the features that are available through the use of the portal. You can essentially submit the proof of representation, the beneficiary consent to release, or the insurer letter of authorization. You can request conditional payment information. You can request copies and actually print out the conditional payment letters that were issued in the claim. You can also dispute the claims. These are some other things that you can do on the portal as well. You can initiate a demand letter. You can submit case settlement information. You can also submit a waiver, compromise, or redetermination request. There are other options when it comes to conditional payment amounts. There is the self-calculated conditional payment amount, which is available under certain specific facts. It only applies to physical trauma-based liability settlements. The settlement must also be less than or equal to $25,000. The date of incident also has to be at least 6 months prior to submission of the self-calculated amount, and there are also specific timelines that must be followed. The fixed percentage option is also available for physical trauma-based liability settlements. This feature is available when the settlement is less than or equal to $5,000. There are also specific timelines associated with this option. Now that we've considered what Medicare's interest is in conditional payments, let's turn to what Medicare's potential interest is in post-settlement injury-related care. We do not have the sort of guidance in the liability arena that we do when it comes to workers' comp guidance from Medicare. What we do have, though, is we have notice of proposed rules that have been put out for liability cases by Medicare in December of 2018, and they have been continuously kicked with the new proposed release date, supposedly in October of 2021. This proposed rule basically states that existing Medicare secondary payer obligations associated with future medical items, services related to liability insurance, no-fault insurance, and workers' compensation settlements judgments, awards, or other payments are going to be clarified. And specifically, the rule would clarify that an individual or Medicare beneficiary must satisfy Medicare's interest with respect to future medical items and services related to these settlements, judgments, awards, or other payments. And this language is consistent with Medicare's prohibition from making payment when payment has been made or is reasonably expected to be made under a workers' comp, liability, or no-fault plan. When these proposed rules came out in December of 2018, needless to say, the industry was very concerned about what this notice of proposed rulemaking would look like. So in Baltimore in the fall of 2019, there were behind-the-scenes meetings that were held between the CMS decision makers and top MSP compliance professionals. And the bottom line is that Medicare really is ready to go with a voluntary review program for liability MSAs. The voluntary program may be similar to the voluntary review program that is provided to workers' compensation settlements, although it would be a bit more difficult to really implement given the differences between liability cases and workers' comp cases. What the decision makers also indicated is that this would apply to Medicare beneficiaries as well as those with reasonable expectation of Medicare entitlement. So although we do not have the notice of proposed rules out at this time, the key to any sort of Medicare Secondary Payer compliance really stems from the Medicare Secondary Payer Act. Whenever you have a client that is a current Medicare beneficiary or is likely to be on Medicare in the relatively near future after the case settles, one of the first things that you should really address is whether this client is likely to need future injury-related Medicare covered treatment. If they are on Medicare and they are going to continue to need injury-related treatment after the case settles, and the settlement includes funds for future medical, meaning that the need for future medical was part of your settlement negotiations, you should consider how to avoid any appearance of a cost shift of post-settlement injury-related care to Medicare. And one of the ways to do that is to actually apportion some of the net settlement proceeds to be used for future injury-related Medicare covered treatment. That would be a Medicare set-aside. If you have a situation in that fact pattern where the net settlement is discounted, as most settlements are, when you're looking at the total potential case value, an apportionment or reduction analysis would also be appropriate, and it would support putting aside less than the full funding of the MSA because the settlement is less than the total potential case value. Another thing to consider when you're settling a case with a current Medicare beneficiary is this a situation where the treating physician would provide a written certification that all injury-related care has completed and that no further injury-related care is appropriate? That type of a certification is consistent with Medicare's September of 2011 memo that states that when you have that, no liability MSA is needed. So there are many different considerations that play a role in the best way to address post-settlement injury-related Medicare covered treatment. Medicare Secondary Payer Compliance is a specialized area. If you are not comfortable with addressing the impact of the Medicare Secondary Payer Act on your client's settlement with your client, you may want to consider a Medicare expert case evaluation. We do offer this at Synergy Settlement Services. There are 3 outcomes that are possible from this MECE consult. There is either going to be an analysis that no MSA is appropriate, or a recommendation that a Medicare set-aside analysis be completed. If your client, after participating in a consultation where the pros and cons and risks and benefits of various approaches are discussed, decides that they would prefer not to do anything, we would complete a Medicare set-aside acknowledgement and waiver for your client so that you have proper documentation in your file. Section 111 mandatory insurer reporting is the enforcement mechanism for the Medicare Secondary Payer Act. It requires primary payers to report settlements that are made for cases involving Medicare beneficiaries. So the way that this works is that the responsible reporting entity for the primary payer or the defendants must notify Medicare of any settlements involving a current Medicare beneficiary when the settlement exceeds $750. Workers' compensation cases have a slightly different reporting obligation in that when the workers' comp carrier accepts a workers' comp claim involving a Medicare beneficiary, they have to report an ongoing responsibility for medical or ORM report. That is also something that may be reported when you have a MedPay type of policy making payment. So these responsible reporting entities, or RREs, have an obligation to query the Medicare system on a regular basis to ensure that they identify claimants that are eligible for Medicare. And when the case in a liability case is completely settled, and this is true for workers' comp as well, there's an obligation to report the settlement to Medicare. It's called Total Payment Obligation to Claimant, TPOC report. And so the date is the date that the payment obligation was established. If it's a situation where you need a written agreement to be signed, that is going to be the TPOC date. It's not going to be the verbal date when you do require a written agreement. If this written agreement has to be approved by the court, the TPOC date is going to be the date that the court approves it. So when it comes to this TPOC reporting, it's really important that everybody be on the same page in terms of what the correct date of accident is being reported, as well as what type of case is being reported and what conditions are being reported as part of the settlement. The information that is going to be reported under Section 111, there are certain data points. So the RRE is going to be reporting the injury victim's first name, last name, date of birth, gender, the Social Security number, last 5 digits, or the Medicare beneficiary identifier numbers. So when the plaintiff is asked to provide this information, this is perfectly appropriate information to share with the defendants because of this mandatory insurer reporting obligation. I mentioned earlier that TPOC report is going to have the ICD diagnosis codes for the alleged injuries that are claimed or released. Medicare actually, quote, encourages the RRE to supply as many valid ICD-9, ICD-10 codes as possible, as that will lead to more accurate coordination of benefits, including claim payments and recoveries when applicable. Now, Medicare obviously wants to recover as many payments that they believe should have been paid by the primary plan or from the settlement. They also want to avoid making improper payments. It's really important, though, that you, as a representative of the plaintiff, have a discussion with the defense to make sure that everybody is on the same page in terms of, what does this case actually involve? What conditions are truly injury related and what conditions are being settled in this case? Your initial pleadings might throw, everything under the kitchen sink in there, but if the medical no longer supports these claims, your settlement is actually going to be a streamlined settlement compensating the body parts that truly were injured. So it's good to have a meeting of the minds with the defendants when it comes to this Section 111 reporting of diagnosis codes. To do that, it'll just make everything go much more smoothly for the plaintiff when it comes to Medicare authorizing payments for treatments that are not injury related. There has been discussion of final rules regarding civil monetary penalties for Section 111 reporting violations. In February of 2020, CMS put out some proposed rules which would outline how penalties for improper Section 111 reporting would be implemented. And the SMART Act originally suggested that penalties might be incurred up to $1,000 a day for each day of noncompliance for each claim. The current discussion regarding civil monetary penalties is that it would be appropriate to perhaps fine up to $1,000 for each day of noncompliance when you have an RRE that completely fails to report within 1 year of the coverage effective date, the date of settlement, or the establishment of payment obligations, or if they're providing Section 111 information that conflicts with information that they're giving in response to conditional payment recovery efforts. So given the expectation that we're actually going to have final rules regarding these civil monetary penalties, those in the industry that are engaged in Section 111 reporting are seeing many of the carriers getting ready and gearing up to make sure that their Section 111 reporting protocol is proper. And you could expect a trickle-down effect essentially with carriers being much more assertive in terms of trying to identify these Section 111 codes that should be reported. This is one of the reasons why it's very important that you do try to coordinate the reporting of codes so that they are accurate. They are not overly broad, and everybody is on the same page when it comes to this. The Provide Accurate Information Directly Act, also known as the PAID Act, was passed into law in December of 2020. What this PAID Act legislation does is that it requires CMS to provide information upon request to a non-group health plan regarding a beneficiary's enrollment in a Medicare Advantage plan or a Medicare Part D plan during the preceding 3-year period. And this information is going to be accessible through the Section 111 reporting database. And even though this information will be provided to the defendant, to the primary payer that is doing the Section 111 reporting, as I mentioned earlier, you as a person who's representing the Medicare beneficiary could access this information through mymedicare.gov. But it will now be easier for defendants and primary plans to identify the various Medicare Advantage plans that may have an interest in seeking reimbursement of payments that were made. Now, some of the things that you may have come across after you reach a verbal settlement agreement might include the defense providing you with 2 pages of MSP compliance terms. And the compliance terms are likely something that was never discussed in connection with your settlement. We've seen situations where the defense puts in an obligation that the plaintiff secure a written certification from the treating physician that no further care is needed that is injury related. That in and of itself would not be problematic if that was something that was actually discussed in connection with the claim. We've also seen situations where the defense is going to unilaterally put in a requirement that the plaintiff fund a Medicare set aside. We have seen language where the defense wants the plaintiff to agree to never bill Medicare. So clearly, these provisions are not provisions that are appropriate for many of the cases that are being settled. Other issues that we've seen in regard to Medicare Secondary Payer compliance terms are when the terms simply cannot be met. If the provisions require the plaintiff to submit a liability Medicare set aside to CMS for review, that is really not an option most of the time, and it shouldn't be in there. We've also seen very inconsistent MSP compliance settlement terms where in one part of the paragraph, everybody is agreeing that the plaintiff is not on Medicare. Yet a few sentences down, there's an obligation to reimburse Medicare for conditional payments. If you are not on Medicare, there aren't any conditional payments. One of the more egregious terms that I recently came across involves a statement where the releasing party is expected to understand that acceptance of settlement funds may affect her rights to other benefits, including but not limited to the suspension or revocation of Medicare benefits at Medicare's sole discretion. So this provision as written really is inconsistent with any potential exposure under the Medicare Secondary Payer Act. Because the plaintiff is a Medicare beneficiary in this case, and she's receiving a great deal of treatment for non-injury related, you know, conditions, this was extremely threatening for her, and it essentially blew the settlement. We have seen some litigation to enforce settlement terms that include provisions that were never agreed upon. In Capilati versus Village of Timber Creek Association, we have the Superior Court of New Jersey in January of 2021 deciding that the plaintiff was entitled to have a motion to enforce her settlement agreement granted. And this dispute arose from the defense adding terms that required the plaintiff's treating physician to certify that she would not require any additional treatment or monitoring. And this request was never discussed during the settlement negotiations. The defense argued that the inclusion of this requirement regarding future treatment was standard practice. The court did not buy it. They found that it was inconsistent with industry customs, and the plaintiff was allowed to enforce the settlement agreement. So, how do you actually prevent these problems from cropping up after you finally reached a tentative settlement agreement? One of the ways to make sure that you can avoid this is to actually have a good understanding of what the MSP compliance obligations are in a case. And if this is something that is not within your area of expertise, it would be prudent to consult with an outside expert. So the next step after you know what the Medicare secondary payer obligations are is to have a discussion with your client about how the Medicare Secondary Payer Act may actually impact their settlement once the settlement papers are approved by the court. Once you have this decision of how to proceed in terms of MSP compliance, you should, of course, document the decision and act upon it. Synergy has a whole suite of services that provide Medicare secondary payer compliance. We are able to assist in identifying conditional payments, whether they are through traditional Medicare or through Medicare Advantage plans. We dispute and we help resolve and seek financial waivers for hardship arguments when it comes to conditional payments. Synergy provides a Medicare expert case evaluation consultation, or the MECE, which is very fact specific and involves a discussion with the plaintiff's attorney as well as the plaintiff to talk about what potential interest Medicare may have in the settlement. This discussion allows everybody to be on the same page in terms of understanding the pros and cons of various approaches. The deliverables from this MECE consultation might include a recommendation for a Medicare set-aside, which then might be followed by a reduction analysis once completed, or a no MSA evaluation letter, given the unique circumstances of the case, or as mentioned earlier, it may result in us preparing an acknowledgement waiver form for the injury victim to sign off, basically confirming that they have been counseled and advised as to Medicare's potential interests in the settlement. We also have a Medicare Secondary Payer Compliance Audit Service, which takes care of the conditional payment identification. It addresses the potential future medical issues when it comes to Medicare. It also identifies the appropriate ICD-10 codes for Section 111 reporting, as well as appropriate settlement terms. Synergy has structured settlements. We partner with a professional custodial account administrator for Medicare set-asides, and we're also able to provide guidance when it comes to on maintaining eligibility for income-based benefits such as Medicaid. So at this time, we are going to begin the live Q&A session. Thank you for your participation. Synergy Settlement Services provides a wide variety
So we have
of
one question.
services that can help you, the attorney, when it comes to resolving various issues with your claim after settlement. We offer Medicare Secondary Payer Compliance, government benefit preservation, settlement planning, assistance with group projects, attorney fee deferral, as well as healthcare lien resolution.
All right, so I apologize for that little interruption there. So this does end the pre-recorded portion of our webinar, and we are now opening up for a live Q&A. So the first question that we have in the chat, and if you do have questions, please put them in. So first question, is it currently required to do a set-aside analysis in every case, or what should we be looking for as to when a formal set-aside analysis should be done or a set-aside created? And that really is a great question. You know, what you should do as the attorney, you should screen every case and you should keep MSP compliance issues in mind. So when a person comes to your office and they're actually a Medicare beneficiary, you know, the first thing you should consider is, okay, what sort of a Medicare plan are they enrolled in? If they're enrolled in traditional Medicare Part A and Part B, you know that you're going to have to check the BCRC for conditional payment information. If they're enrolled in a Medicare Advantage plan, you should note that you have to reach out to that Medicare plan, the specific Humana, for example, or Blue Cross Blue Shield plan and so forth. So, you know, that is one part of what you should consider. You should then look at, well, what type of injury is involved? I mean, if this person has a soft tissue injury that healed with conservative treatment, this might be a situation where you can address Medicare's potential interest in the settlement through a treating physician written certification that all injury-related care has been completed, no further injury-related care is needed. If you have a second type of fact pattern where you do have significant injuries and a person is going to need post-settlement injury-related care, but you have policy limit issues. You know, if your objective economic damages like past medicals exceed or eat up most of the policy limits, there's no attempt to inappropriately cost shift post-settlement future injury-related expenses to Medicare. You just don't have enough funding in here. On the other hand, though, if you have a situation where your client has an injury that is being settled, when your settlement is going to be sufficient to fund future medicals, you're arguing that, you know, my poor injury victim, they're going to require all these additional surgical procedures and so forth. You know, that is a situation where you actually should get Medicare set-aside allocation. And depending upon the amount of the Medicare set-aside allocation, it might be appropriate to have it then apportioned or reduced because of the fact that the net settlement might be significantly less than what the total potential case value is, or your settlement offer is after you deduct the liens and so forth. So the key is that, you know, each case really though might have a different end result depending upon the facts of the case. I do think it's very important when you are representing a Medicare beneficiary or somebody who is going to be on Medicare in the foreseeable future, and it's a situation where they, you know, might require future medical treatment, or they're just concerned about potentially losing coverage for post-settlement injury-related care, it's a good idea to have a discussion with them about the Medicare Secondary Payer Act implications in the case. If this is not something that you are comfortable doing, I would recommend that you consult with an outside expert such as Synergy and you document your file. All right, let's see if there's another question here. All right, the next question that we have here is, does defense have the right to request the plaintiff to put on notice a spouse or child of a decedent for mental health treatment. For example, husband dies as a result of medical negligence. The wife receives mental health treatment as a result. The defense required us to put Medicare on notice for the wife's injury and provide conditional payment accordingly. So, when we're talking about Medicare as a secondary payer, they are a secondary payer when there is a third party that is responsible for the injuries that are being claimed and are being settled in a case. So in this specific question that we were asked, it appears, if the wife is being compensated in connection with this type of case for the psychiatric mental health treatment that she received, and that is part of the case that's being settled, Medicare does, they're going to be given notice of any settlement that exceeds $750 for physical trauma type of injury in a liability case. And they are also going to likely seek conditional payment recovery if payments were made. And so a lot of this answer really depends on, what sort of case this particular case is. If it's a loss of consortium claim and she's filing a separate claim and she's a Medicare beneficiary, then Medicare would be entitled to be reimbursed for the conditional payments that they made. All right, let's see if there's anything else here. Okay. Do we have a list of the major Part C insurers with contact information for reporting the liability claim? There are many different, Medicare Advantage plan carriers that are out there, and they usually have contracts with various recovery contractors. So we would recommend, since information can always change, that we don't have a static list because, as I mentioned, the information is always changing. So one of the ways that you might be able to get this information is, I believe by December 11th of 2021, all of the information regarding these Medicare Part C plans and Part D plans pursuant to the PAID Act is going to be something that the defense is going to be able to access through the Section 111 reporting. You should also be able to get this information if you have the appropriate proof of representation and so forth by reaching out to the BCRC. Mymedicare.gov is also another resource where the injury victim can register online to see, if they're confused about which plan they were enrolled in. That is another great resource for getting this information. And let's see. Okay, so we do not have any additional questions at this time, and we are at the 60-minute mark. So thank you very much for your attention and for your time. If you do have questions or there's anything that we can assist you with in the future, please reach out to Synergy. Thank you.